Welcome back to Big Law University. This is Big Law University presents Warrants. This is part one of a three-part series. We're going to be discussing what they are, why they matter, and how they are obtained. So we're going to go ahead and get right into this right here. So part one of this three series, we're going to be laying the foundation of government action, searches and seizures. Now you understand when the Fourth Amendment even applies, but now we move on to the next level. The question isn't just whether a search or seizure happened. The question is whether it was constitutional, whether the government had the right to do what it did. And that conversation starts with one word: the warrant. Most people think they know what a warrant is. A piece of paper, a judge signs it, the cops show up, but the legal reality is far more precise and far more important than that. Because whether or not a warrant was obtained and whether or not it was valid determines whether evidence gets used against you in court or thrown out completely. So, what is a warrant? At its core, a warrant is a judicial authorization for police action. The government wants to search your home, seize your property, or arrest you. But before they can do that lawfully, they need a neutral third party to sign off on it. The third party is a judge or magistrate. That sign off is the warrant. Now, here's where most people get it wrong, and this is critical. The text of the Fourth Amendment does not say that a warrant is required before every search or seizure. Read it for yourself. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Notice what it actually says, that the only thing the Fourth Amendment prohibits is an unreasonable search or seizure. It mentions warrants, but it does not say a warrant must exist before every single search. What it does say is that a warrant is going to be issued. If a warrant is going to be issued, certain requirements must be met. So the real question in every Fourth Amendment case is simply this: was the search or seizure reasonable? If it was reasonable, the Fourth Amendment was not violated. If it was unreasonable, it was. That's the whole game. But as you'll quickly learn flipping through any criminal procedure casebook, the Supreme Court has built some sort of maze of complications, sometimes contradictory rules around what counts as reasonable. In Ranobitz, United States versus Ranobitz, decided in 1950, the court itself acknowledged that reasonableness is not a simple concept and that drawing lines in the area has never been clean or easy. So in plain English, think of it like this: the Fourth Amendment isn't a magic shield that requires a warrant for everything the government does. It just says the government cannot act unreasonably. The warrant is the cleanest way to prove the government acted reasonably, but it is not the only way. The warrant presumption, why it still matters. So, even though the Fourth Amendment doesn't mandate a warrant for every search, the Supreme Court has said that any search or seizure conducted without a warrant is presumptively unreasonable. The court reinforced this in the case Kylo versus United States, a 2001 case we actually covered in parts 1 and 2, where the court held that warrantless searches are presumed invalid unless the government can justify them. Now, presumptively unreasonable does not automatically mean unconstitutional. It means the burden shifts. The government has to prove the search was reasonable despite the lack of a warrant. And the way they usually do that is by showing that the situation falls within one of the exceptions to that warrant requirement that the Supreme Court has carved out over the decades. We'll get deep into those exceptions in future videos, but for now, understand the baseline. No warrant, presumed unreasonable, the government has to justify it. So in plain English, no warrant, the government is already on the back foot. They do not automatically lose, but they have to explain themselves, and that explanation has to fit into one of the specific exceptions that the courts have approved. Otherwise, the evidence will get thrown out. Requirement 1, the neutral and detached magistrate. All right, now let's talk about what makes a warrant valid. There are specific requirements, and if any of them fall, the warrant can fall with it. So the first and arguably most important requirement is this: the warrant must be issued by a neutral and detached magistrate. This rule comes from Shattuck versus the City of Tampa, a 1972 Supreme Court case. The reasoning is simple but powerful. The government cannot be the one to authorize its own searches. That would be like letting a player call his own fouls. You need an independent decision maker, someone removed from the heat of the investigation to evaluate whether the search is actually justified. So, what does neutral and detached actually require? 3 things. First, the magistrate must have complete separation from law enforcement. No affiliation with the police, no role in the investigation, no connection to law enforcement activities that could cloud their independent judgment. The court in Chadwick made clear that any entanglement with law enforcement, anything that would distort independent judgment, disqualifies the person from issuing the warrant. Second, the magistrate should generally come from the judiciary, not from the prosecutor's office or the police department. Bloom and Bruden put it plainly in their criminal procedure text. The magistrate should usually be a judicial officer, not a law enforcement official. Third, the magistrate must have no financial stake and no personal interest in the outcome. This comes from the case Connolly versus Georgia, a 1977 Supreme Court case where a justice of the peace was paid a fee for every warrant he issued, but received nothing if he refused. The court struck that arrangement down immediately. You cannot have a magistrate who profits just from saying yes. In plain terms, picture a referee who gets paid every time he calls out a foul against the visiting team. That's the case of Connolly. The Fourth Amendment doesn't allow a financially motivated gatekeeper. The person signing the warrant has to have zero personal interest in whether it gets signed. Now, who can be the magistrate? The title usually means a judicial officer, but the Supreme Court in Chadwick clarified it does not have to be a full judge. It can include inferior court personnel, clerks of court, and others. The key is that whoever it is must have the training and competence to actually evaluate probable cause. Generally, a judge or attorney satisfies this automatically, but a law degree is not technically required as long as the person can make the legal determination the Fourth Amendment demands. So here's a law school exam tip. If a fact pattern shows the warrant was issued by a police officer, a prosecutor, or anyone with a stake in the outcome, the warrant is invalid on the ground alone before you even get into probable cause. Now, requirement number 2, probable cause. So, the second requirement for a valid warrant, you guessed it, it's probable cause. This is the one everyone has heard of, but understanding it at a constitutional level is a different thing entirely. The Fourth Amendment requires that before a warrant is issued, the magistrate must make an independent determination that probable cause exists to believe that a crime has been committed and that a person or place named in the warrant is connected to that crime. That standard again comes from Shadwick. Typically, the police or prosecutor's office applies for the warrant by submitting a sworn written affidavit. An affidavit is a formal statement signed under oath laying out the facts they're relying on. Sometimes it's done through oral testimony instead. Either way, the oath or affirmation requirement in the Fourth Amendment is being satisfied. The government is swearing that they are telling the magistrate what they are telling the magistrate is true. When the magistrate evaluates probable cause, they're actually making 2 determinations. First is the information in the affidavit based. Is it sufficiently reliable, specific facts? And second, does the information actually amount to probable cause? We'll handle the second question in the next video. Right now we're going to be focused on the first, which is reliability. So, in plain English, the cops cannot just walk into a judge's chambers and say, "Trust me, these guys are dirty." They have to submit real sworn facts, and the judge has to independently decide whether those facts are solid enough to justify a search. So, as I promised, reliability, where the probable cause fight happens. So, the probable cause determination has to rest on specific and concrete facts, not hunches, not a gut feeling, not speculation, but real articulable facts. If the source of information is the officer's own personal observations, that's almost always going to be considered reliable. The officer saw it, the officer is under oath, done. Hearsay from named third parties, a crime victim, an identified witness the officer names in the affidavit, someone who can be reached for a follow-up, is also generally deemed reliable, especially if the information is detailed and specific. But the real battleground is this: what happens when the information comes from an anonymous informant? Someone whose identity is unknown or deliberately not revealed. This is where courts do the heavy lifting. So for years, courts applied what they understood to be a rigid 2-pronged test for evaluating anonymous tips. Prong 1, the affidavit had to establish the basis of the informant's knowledge, meaning, how did this person come to know what they claim to know? Did they witness it directly? Were they told? Did they participate? Prong 2, there had to be enough information to show either that the informant was generally credible and truthful, or that the informant was saying was specifically true in this case. Then in 1983, the Supreme Court in Illinois versus Gates changed the whole game. The court said, stop treating these 2 factors as a rigid checklist where each box has to be independently checked off. Instead, courts must weigh all the factors together, basis of knowledge, credibility of the informant, and truth in the particular circumstances, and ask whether under the totality of everything the informant can be relied on. The practical effect: if one factor is weak or missing entirely, a strong showing on the other factors might make up the difference. So in plain English, courts used to grade anonymous tips like a pass-fail test. If even one requirement was missing, the tip failed. Gates threw that out and said, look at the whole picture. A weak source can be rescued by overwhelming corroboration. A strong source with a minor gap in their story might be reliable enough. Now, how the Gates factor plays out in practice. So let's go ahead and make this concrete. The Gates framework gives us 3 factors to balance: basis of knowledge, credibility, and the truth in the circumstances. Here's how each one can carry the others. Factor 1, credibility. If a confidential informant has a long track record of proving accurate, reliable information to law enforcement, that credibility can compensate for a gap in their explanation of how they know what they know. In Gates itself, the court said a history of unusually reliable tips and accurate predictions can overwhelm the other factors and permit probable cause finding even when the basis of knowledge is not fully explained. But the critical limit: the police cannot simply tell the magistrate this informant is reliable without providing specific facts to back that up. A bare assertion of credibility is worth noting. Gates makes that clear. Factor 2, statements against interest. When an informant tells police something that could expose the informant to criminal liability, for example, admitting they purchased drugs from the people they are tipping on, that self-incrimination detail dramatically increases the credibility of the tip. Why would someone confess to a crime if the underlying information wasn't true? The Gates court recognized that statements against penal interests can carry their own inherent reliability, and that this can compensate for a weak showing of other factors. Factor 3, the basis of knowledge plus corroboration. If the informant claims personal observation, I was there, I saw it myself, and the details are specific enough that the inference of personal knowledge is reasonable, the basis of knowledge factor can carry the other 2. This is especially powerful when police have independent corroboration evidence that lines up with the informant is saying. In Gates, the court emphasized that the independent police corroboration is exceedingly helpful. It can take a constitutionally shaky anonymous tip and make it reliable enough to support probable cause. So, in plain English, the more the informant's story checks out against things the police already know or can independently verify, the more reliable that informant becomes. Think of it like a credit score. Multiple positive factors can compensate for one negative one. No one factor alone is automatically disqualifying or automatically sufficient. So let's run a hypothetical. Now let's make this real. We're gonna walk through a hypothetical, the kind you'll see on a law school exam, and we'll apply everything that I just covered. So pay attention. An anonymous tipster sends a typewritten letter to the police. It says, Bruno and Esmeralda are cooking meth out of their basement at 123 Makeup Lane. Question 1. Is that letter alone enough to support probable cause? Yes or no? The answer is no. Almost certainly not. The letter is anonymous. There's no way to assess the tipster's credibility. The letter states its conclusion without explaining how the tipster knows any of this. It's bare, it's conclusionary. All three gate factors are empty. A sensible magistrate refuses to sign that warrant. Now, we're gonna add this to the letter. Let's pretend that the letter also says, I know this because earlier today, I bought an ounce of the blue meth from them at their house, and separately, the police have been dealing with a wave of unusually sky blue crystal meth in the area. So question 2, does this change the analysis? It does, but it's not all right. Now the letter provides a basis of knowledge. The informant claims to have personally purchased from the suspects at that specific address. The mention of blue meth and the location gives specific detail to infer personal knowledge, and the admission of drug purchase exposes the tipster to criminal liability, a statement against penal interest, which adds credibility. Plus, the police already know that blue meth has been circulating. Independent corroboration, thin but present. This letter is on much better footing, but experienced prosecutors would want more before going to the magistrate. Now, we're gonna add a final layer to this scenario. Say the letter arrives with an enclosed bag of the bright blue crystalline rocks, which the police test and confirm is high purity meth. Officers conduct surveillance outside the house and observe plumes of smoke rising daily from the basement windows, something that they know indicates the production of meth, and they watch local individuals make brief visits to the house, exchanging money for packages, which they immediately conceal on their persons. So, question 3, can the magistrate now rely on the informant's letter? Almost certainly yes. The letter now arrived with actual physical evidence. Tested meth. Surveillance independently confirms manufacturing activity through the smoke, and the pattern of brief cash for package visits establishes distribution. The informant's tip has been corroborated from multiple independent directions. Every Gates factor that we discussed is satisfied here. This is a warrant application that can stand up. So in plain English, the lesson from the hypothetical, the anonymous tip that starts as a worthless piece of paper becomes constitutionally valid as police stack corroborating facts on top of it. The tip doesn't have to be perfect, it just has to be reliable enough under the totality of the circumstances for a neutral magistrate to say, yes, there is probable cause here. So let's lock this in. A warrant is a judicial authorization for government action. The Fourth Amendment does not require one for every search, but without one, the government is presumed to have acted unreasonably. For a warrant to be valid, 2 requirements dominate today's video. 1, it must be by a neutral and detached magistrate, someone independent, someone with no financial stake, someone with no law enforcement entanglement. No neutrality, no valid warrant. 2, it must be supported by probable cause, and that probable cause must rest on reliable specific facts, not hunches. When anonymous informants are involved, courts use the Gates totality of the circumstances test, balanced basis of knowledge, credibility, and corroboration together to decide if the tip can be trusted. So for law students, Gates is the framework you reach for every time an anonymous tip appears in a fact pattern. Ask yourself, what do we know about the basis of knowledge? What do we know about credibility? What corroboration exists? And can the strong factors rescue the weak ones? Now, in part 2 of Warrants is coming, we get into the actual probable cause standard, what it means numerically, and the particularity requirement. These are the details that make or break a warrant on appeal. Subscribe to Big Law University, share this with someone in your study group, and if you're here just to know your rights, you're in the right place. Big Law University, know the law, own the room.